Welcome to Employment Law This Week. I'm George Whipple. Our top story, the Department of Labor's Wage and Hour Division offers its interpretation of joint employment. The division issued an administrator's interpretation with new guidelines for joint employment under the FLSA and the Migrant and Seasonal Agricultural Workers Protection Act. The division makes it clear that it believes employers are regularly part of joint employment relationships with their vendors and business partners. If an employee files a claim or lawsuit and a joint employment relationship is found, both employers can be found liable for violations. Michael Thompson has more.
The administrator's interpretation talks about two different types of joint employment. The first is vertical joint employment, which typically involves a relationship between a company and its vendor and the vendor's employee. The second type of joint employment relationship is a horizontal joint employment relationship, which involves relationships between two separate but related companies that are employing the same individual. Employers need to continue to be mindful of whether or not their contractors' employees are economically dependent on the company, are controlled by the company. Now companies need to be a little bit more mindful of whether or not they're sharing employees with related companies. But the most important thing is that companies who are selecting vendors need to make sure they're using quality vendors who are aware of their legal obligations, are complying with their legal obligations, and will enter into indemnification agreements that cover any joint employer liability that might arise.
The EEOC issues draft guidance on retaliation claims. The Equal Employment Opportunity Commission is soliciting comments on new guidance for retaliation against employees who file discrimination claims. The agency last offered guidance on the issue in 1998, and the percentage of retaliation claims has grown by roughly half since that time. Taking into account significant rulings from the Supreme Court and lower courts on retaliation, the proposed guidance, among other things, adds extensive guidelines regarding retaliation against employees seeking accommodations for disabilities, and makes it clear that the EEOC considers prohibitions on discussing compensation to be highly suspect. To submit your comments, go to regulations.gov by February 24th. The 11th Circuit limits the supervisory misconduct offense against OSHA citations. At a construction worksite, a supervisor and his subordinate from Quinlan Enterprises were found working on a 15-foot wall without fall protection or a secure ladder. The company was held responsible for the OSHA violation because in most cases, a supervisor's knowledge of a violation is imputed to the employer. Quinlan appealed, citing the 11th Circuit's Comtran decision. Comtran held that when a supervisor participates in the violation independently, that supervisor's knowledge of the act is not sufficient to establish that the employer is aware. The Quinlan court disagreed, noting that the Comtran exception does not apply because the supervisor was not the sole participant in the violation. No accommodations for medical marijuana in New Mexico. A district judge in Albuquerque ruled that Tennessee-based Tractor Supply Company did not violate the law when it fired an employee who tested positive for marijuana. The employee uses medical marijuana under a doctor's recommendation, and he informed a hiring manager of his use during the hiring process. The judge found that the employer had no duty to accommodate the use of the drug that is illegal under federal law. And that brings us to our tip of the week. Here's Andrew Lauer, General Counsel for Yeshiva University, with advice on how to manage an employee during the employment life cycle.
I often counsel my clients that managing an employee from start to finish throughout the employment life cycle is the best way to avoid a claim and have a productive employee. When they come in and they're a new employee, orient them, explain to them what the expectations are. As they're working for you, if things are not going well, tell them about it. Communicate, meet with them, explain to them what they could do to improve their performance. If things are really not going well, set up a performance improvement plan. Always document what you're doing so that later when your attorney wants to look at a file, there's documentation to support your efforts. And at the end of the day, when someone is terminated, this should be no surprise to them.
Thanks, Andrew. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next week.